Okay, Rebecca is Trust Administration Officer at Central National Bank in Topeka, and she's worked in trust field for over 20 years. And Kathleen has her own law office, Urbaum Law Office, and she went to Washburn Law School and University of Kansas, and she is an expert in wills, trust, probate, corporate, forming corporations, and handing those down. What do you call that? When you end your corporation? Succession planning, yeah. So anyway, these ladies are very versed in what you're going to be talking about tonight. And I'm not going to stand up here and yak about everything. I'm just going to let them get started. We do have cake. I know everybody saw the cake tonight. So we're going to have that at the end of the program during the Q&A. So we will be sure that we don't get out here without having cake. So who's going first? Kathleen? Okay.
We'll do it.
Kathleen Urbaum. Thank you.
Very much. You're welcome. Thank you all very much. I'm delighted to be here this evening. Rebecca and I worked on this a couple of years ago and then this last year, and have really enjoyed the process of making sure that we're covering all the topics that we think might be directly relevant to end-of-life planning. And we kind of started, and I know there's a clicker, so forgive me while I get familiar with this. Do I go up or down, Megan? Over. Okay. We'll go ahead and talk about issues that affect planning for changes in life and for end of life. And the reason we distinguish between those two events, for example, when you have a will, it takes care of making sure your wishes are known after you die. There are many other situations, especially in today's world, where you can become disabled long before you die. And you want to make sure that you have both the documents and the planning in place that allow those who care for you and those who have your best interests at heart to help you manage whatever you would like to have done during that period of time. In addition to that, there are so many state and federal regulations that impact what we do and how we do it and who can do what kinds of acts. And so that's another thing that we try and look at as we go through this to make sure that we have the instruments in place and the planning in place so that you know how to deal with potential situations that arise. So you have the federal and state government. All of you guys probably know about Social Security. There's all kinds of retirement plans that are covered by federal laws and that have restrictions on when they vest and or when you can access them or when survivors can access them. You have Medicare and Medicaid, which impact funds that may be available to take care of you if you're ill and may be available to take care of one of you and the other one doesn't have that need at that time. And then you have marriage itself, that in each state, and specifically in Kansas, creates spousal rights. And certain of those rights simply cannot be disavowed unless you get a consent that's actually signed by the spouse. You have children, former and current marriages, and adoption. And each of these legal statuses can affect what happens if you're either disabled or you die. Then you have your own future incapacity, which we talked about just a little bit. You have special needs. You may have a child, an adult child. You may have an elderly parent. I'm guardian conservator for my youngest brother who was traumatically brain injured in a car accident when he was 9. And so I have that ongoing obligation. I know I have to plan for what happens if something happens to me. I'm the oldest of 8 children. He's the youngest. And so we have, intervening siblings, and now we have children and nieces and nephews that may have an interest and be able to step in. But those are all issues that need to be discussed. You have ownership of business interests. And depending whether you're self-employed and what form of entity that is, what type of investment it may be, there are special planning considerations around how to make sure that the rights or title or interest to that business actually gets conveyed in the way that you want it. For example, most LLCs, if you've heard that term, limited liability companies, have operating agreements that restrict the voting rights of a member who dies and whose interests pass to their survivors. And so you want to make sure if you have an ownership interest in an LLC that you have made provisions with the other members for the individual or the person who would take over your interest and have had that discussion. In many LLCs, it's not because they don't like the family members, but they function like a partnership. And so they're simply not accustomed to working with that particular partner, and most of the time they're not especially interested in working with a different partner. And so you have to make some type of arrangements that allows that to be addressed and allows those interests to get converted to monetary value of some kind through insurance or a buyout provision so that you actually get the benefit of the ownership interest. You have tax consequences, and we'll talk a little bit about that. It's part of answering the question of when do you need an estate plan. Right now, we're in a very advantageous tax environment. The state of Kansas repealed its inheritance tax, which was a tax that was paid by an heir, not the estate, but by whoever had the inheritance interest. That has not been in place now since 1998, I think. So, and of course, as each state struggles with their finances, it's something that could always be resurrected. You simply need to be aware of what your state and then what the federal laws are. Right now, the federal statutes are also very generous. You have $5 million limitations per spouse. So if you're married, you actually have effectively a $10 million estate and gift tax exemption. One of the things people have to pay attention, though, to is if they have something that's worth several million dollars and you're 50, is it something that could be worth in excess of whatever that gift and estate tax exemption is if you die at 80, 30 years later? And so those are the type of things you want to talk to an attorney about or a good tax accountant. And then you talk about transition of management of assets. And Rebecca's going to get into that issue in terms of how trusts function. I will tell you that I am a great fan of trusts. And I'll say a little bit more about that later on. But I think they're just one of the most versatile management tools that you can look at. And sometimes it doesn't make sense to have a trust. You have sufficiently limited assets. You really can keep track of making sure they're either titled so they pass on your death or that you have beneficiary designations. But if you have assets that kind of change or that kind of grow, then a trust may be something that you want to look at, and especially if you do have a special needs child. You have probate versus non-probate assets. Sometimes people really don't understand. Probate is a legal process, and one of the things Rebecca and I got last year at the end of our question and answers was, would you please provide, a listing of terms? So on pages 145 and 146 of your book is a glossary of most of the terms that we'll use in the presentation or that might be relevant to these issues. Feel free at the end, even after you've used it as a reference, if you still have a question, feel free to ask. Then you have access to user ID, password, and list of digital accounts issues. That's something, of course, that's been more recent in terms of development, but we see it pop up more and more often. How do I have access to people's accounts? It really influences, too, the actual scope of authority. For example, we typically use a power of attorney to make sure somebody's authorized to act on your behalf. But anybody who has access to your computer, your password, and your user ID on accounts is going to be able to access your accounts online. And so that's one of the things you need to pay special attention to. If you ever have any questions about it, don't hesitate to ask myself. You can call and say, I came to the HCCI Women in Money series, and I have this question. But that's something that we're seeing more and more interest in and more need that people pay attention to. Federal laws, we're kind of going over there. You have estate and gift taxes, you have income taxes, you have securities laws, and you have pension, profit sharing, retirement plans, and insurance. One of the things I'll take just a second on is income taxes. When a person passes away, whatever tax return they owed in the year in which they died still needs to be completed. So if they died on January 1 of 2014, if there's any income in 2014 that's credited to that person, they have to still file an income tax return. If the estate has income, then you also have to get a tax ID number for the estate And that estate has to file a tax return or income tax return as well. So that's something just to be aware of. Kansas laws that affect your rights if you're disabled or your property when you die. You have we mentioned this briefly, marriage and homestead. You have the spousal share. You have divorce and child support obligations. These are all significant things. When you have divorce levels at the levels we do, you have outstanding liens many times for unpaid child support. And if you have an asset, for example, that you jointly own in a second marriage, that individual has unpaid child support and passes away, you may find that there's actually a lien that attaches to part of the property that you thought would come to you. You have titling of real estate in the business interests. And that's a really significant thing that we talk to clients about a lot. And that's where you take a look at whether or not the type of assets you actually own are capable of simply being titled in a way that allows them to pass at your death without having to be probated. Then we have the probate laws for both intestate and testate succession. Intestate simply means you died without a will. When you die without a will, the state of Kansas has a will written for you. And that's called the laws of intestate succession. And typically what it means is, my husband and I are married, we have children. If I die without a will, if I have assets that are titled joint tenant with right of survivorship, they'll go to my husband. But if I had assets that were just in my name, my husband is entitled to 1/2 of that, and our children are entitled to 1/2 of that. So unless you have children that are fully cooperative, you can end up in a situation where part of the cash, part of the vehicles, part of a business they may actually have a claim against that. And if you have anybody who feels strongly about taking their interest now versus later, that is how it ends up passing. So I always encourage people when we talk about the documents that you really do want to have. You want to have a will. I have clients who say, well, I've got a trust. Do I need a will? Yes, you do. A will is your protection that the way you want your assets to pass at your death happens. If, in fact, you've been able to capture all the assets and either title them or designate a beneficiary so you end up without any assets that belong over here under the probate heading, great. But there are events that happen around death that are sometimes beyond your control to do anything, and they exist untitled and no beneficiary designation with your death. Some examples are, and this is always one I think about being Irish, you could die with the winning lottery ticket in your pocket. And if you do, darling, it belongs to you, but it's part of your estate at that point because you haven't claimed it and put it into any other vehicle. You may die in an airplane accident. You may die in a situation where there is negligence on the part of another human being. That can be an automobile accident. It could be, right now, there's all kinds of theories floating around about Ebola. We were laughing earlier. I was at a committee meeting this week where we did the Ebola bump, and that's the new hug or handshake. You just bump elbows. So you don't pass any germs. But there's all kinds of situations in which death occurs that create a liability. And there's no way you could have taken care of that prior to your death because the very event of death is what gave rise to it. Then finally, there's the situations where 2 years later, 10 years later, you really do have that long-lost uncle or that very far-flung relative, and you get that infamous letter from an attorney that says, we have determined that you are an heir in the estate of so-and-so, and you have right title and interest to this type of inheritance. Well, there was no way you could have planned for that either. So I always tell people, regardless, you need a will. Worst case is you take that will at date of death, whoever your executor is, they do an affidavit, they go pay $79 in today's dollars, and file it in the county in which you died. And then it sits there. If you never have to probate an estate, great. But if even several years later you have something that comes into your estate, that estate can be opened and that will can be used to dictate how those assets pass. So one of the other documents that we talk about, and before I go there, I'll talk about guardian conservatorship standards. And I only touch on that because when you have an individual, an adult, who is impaired, meaning that they have been deemed by legal process not to be competent to make decisions on their own behalf, there are special things that you need to consider, both on their behalf and as a result of what they may own. One of the things a lot of people don't realize, if you have minor children, they're considered to have a legal disability. What does that mean? They're not an adult. And so they are not legally entitled or capable or authorized to make certain decisions. And so if, for example, you have a spouse who dies and you have an amount of money that's paid and the child's determined to be one of the recipients or beneficiaries of that claim, that amount of money has to be established in a conservatorship that's set up through the county, through the probate court. And then it can possibly be the other parent, but it might possibly not be the other parent. And so that's something that a lot of folks truly don't understand. And you have all kinds of emotional issues around that. Well, this is my minor child. Why on earth are you saying that I'm restricted and somebody else is going to come in and tell me what to do with that money? It makes no difference if the money legally belongs to the minor child. And so that's one of the issues that can affect who has that, who has an opportunity to control that money, and who has an obligation to take care of it in a way that saves it for the benefit of the child. Since I already mentioned that the state of Kansas has a plan for you, if you don't make one, we say, make your own plan. And that way you have instructions that are available in the event of your disability or death. One of the neat things about a trust, as Rebecca will get into later, it is one of the most effective tools in the event of disability. So if you're disabled for many years, or you're in a nursing home, or you have been in a car crash and you're in a coma, you literally have already set up some tools that'll help, and she'll get into more details on that. So under a will, what's involved with making a will? If you come see me, what kind of information am I going to say you need to bring or we're going to discuss? First of all, we're going to discuss whether or not you're married. We're going to discuss whether or not you've ever been married before this marriage. We're going to ask whether or not you have any children, if you have any children by a prior marriage, or if you've ever had a child that you may have given up for adoption, for example. We're going to ask those questions not because we are prying busybodies, although it has been said from time to time, but because each of those facts make a difference in terms of the rights of other people to make a claim against your estate. And so, in the state of Kansas, you cannot disavow a spouse without their written consent. However, you can disavow children. And you can say, I've provided, I see some are thinking that would be a good choice. And there could be many, many reasons for that. But you can, in fact, say, all my provisions are for my spouse, and then we want it to go to charity eventually. I know some people who have, I've worked with a couple of very wealthy clients, their biggest fear was that in giving their children a large bequest, that it would ruin their child, that it would truly be damaging to that child's self-reliance, self-confidence, and making them a dependent personality rather than an independent personality. And so there's all kinds of legitimate thinking that would cause a parent who is a very loving and caring parent to decide to either limit or eliminate a gift they would make to a child. And then there are other parents who say, this is the reason I was born, was to have children. I want my children and my grandchildren to have everything. In fact, I work day and night because I want them to have something when I'm gone. Those are all, whatever your perspective is, you have a right to that perspective. And what you want to make sure is that whatever that perspective is gets translated into documents that implement what you want to have done when you die. We talked a little bit already about guardian of minor children. One of that issue also comes up, especially in the context of divorces. Natural parents are the natural guardians of their children. You have situations where, because of a divorce when a child is very young, and because of very limited or no contact with the other parent, that something happens to the parent that is their primary residential parent, maybe 5 years, 10 years, 15 years later, and they die. Well, the surviving natural parent has a right to be the guardian of that child. They have a right to make decisions for that child. They have a right to have control over assets that might belong to that child unless it's contested in court. And so when you have a minor child, you have to deal with the reality that both parents have a right to make decisions on behalf of that child. I won't spend but a second on this. There are a lot of what are considered non-traditional family situations today. We see that in same-sex marriages from other states where the couples reside in the state of Kansas. There are parenting plans that they can agree to. And there's also a legal mechanism where if they go through a doctor in order to have that child, that it cuts off the parental rights of either the sperm donor or the egg donor in the event of two males. So that's a whole area in and of and to itself. But it already is having an impact on some of the laws that pertain to, quote, traditional families, and it will continue to have a significant impact as we go forward. So you just want to make sure that whatever it is you want done with your family, that it's a plan that can be implemented because it accords with those statutes. Then a general disposition of assets, that's what you provide for in a will. I will tell you the standard provisions go something like this. I tell my executor, I direct my executor to pay all of what we call the Class 1 demands, which are expenses of last illness, your funeral expenses, your administrative costs, out of the proceeds of any assets that are there. Then I direct them to give, in accordance with a certain written list that I provide at the end of this will, these items of personal property, grandma's ring, grandpa's hunting rifle, pictures, all kinds of personal items that you really and truly want to go to Sarah or Johnny or Ben or Aunt Sue or best friend Mary. You can leave a list and you can modify that list from time to time. You leave it with the will in the same place. It can be a handwritten list and it will serve to be directions about your desires on that personal property. Then it says, anything that I own in joint tenants with right of survivorship, I expect that it will pass to the joint tenant. And then finally it says, everything else that I have in my estate, I give, devise, and bequeath to. And then you say whom. So if you want to give everything away from your spouse, and that may be because you have trust set up, it may be because they have a trust from a family member, and if something happens to you, you don't want to have tax consequences, you don't want to have assets that can be attached. Lots of good reasons, again, that people make these decisions. They want your marital assets to go directly to your children, for example, or directly to a charity, for example. Those are the kind of provisions that you can make in a will. And then finally, you give specific authority for being able to take care of closing the estate, gathering all of the assets that are available, for selling it, for doing all those kinds of things. You have decisions that you make. Do they have to be bonded? Can they serve with or without a bond, in other words? Do they have authority to sell without supervision of the court so that they can qualify for less oversight by the court, which translates into lower costs typically? And so those are the kinds of things. You look at the assets that your client has, you look at the assets that you have, and you figure out where you want them to go, and we talk about if you had to probate this estate, how would you want it handled? What kind of protections do you want? What kind of protections do you think would be overkill and be a cost that you don't really want to see come out of your estate? Another instrument that I think is critical for people, every adult, to have, and that is a durable power of attorney for healthcare decisions. A durable power of attorney as a broad general instrument is an instrument where I nominate another person to act as my agent. And it is as though I cloned my legal self with we call them either general durable powers or specific durable powers of attorney. The durable power of attorney for healthcare decisions is a specific power of attorney. And it says to your doctors and all your medical professionals and your healthcare professionals, this is who I want you to talk to if you cannot talk to me about my care. I want you to discuss what procedures should be done. Here's who I want to sign off if I need surgery, if I need rehab and I'm still foggy or under medications and I can't make those decisions myself, or I'm overwrought from the accident or the illness that brought me into this place. So this says, here's who I trust to make decisions about myself. Like all guardians, a guardian takes care of the person. A conservator takes care of the money and the assets. This durable power of attorney for healthcare decision acts as a healthcare guardian, somebody who's going to talk to those healthcare professionals who are making recommendations about what should happen to your physical body. A living will. This is different. People say, well, if I have a living will, do I need a durable power of attorney for healthcare decisions? Or vice versa. If I have a durable power of attorney for healthcare decisions, then do I need a living will? And the answer is yes, you need each of them. And a living will is a requirement if you ever want anybody to have the legal authority to unplug you from processes that will extend your life. A living will says that at least 2 doctors have to determine that you have no hope of recovery. Typically, the patient is brain dead. That's most typically where this comes about, with no hope of recovery, meaning to ever regain consciousness is what they're talking about. You say in your living will what kind of procedures you want to have stopped or not stopped. 2 that I always take special time to talk about with my clients are stopping food, which is typically through an IV, or stopping hydration. All healthcare facilities are going to provide comfort care. You are not going to see where they're writhing in pain. They are going to suggest, recommend, and be overwhelmingly persuasive that we need to administer at least pain medication in order that that person is not in horrible, excruciating pain with no way to communicate or do anything. That can include dryness of mouth. If you've ever been around the dying process, you know that as your body dies, you do not want to eat and drink many times. That they simply, even when they're offered, even a cotton swab, even an ice cube, they turn away. Their body's telling them, I don't want any more inputs. And so our healthcare industry is geared to taking care of life, to making sure that somebody lives. Without the living will, they are not going to unplug you. When you add the legal liabilities to that, without the living will, that is not an option for you. I have to share a personal example here. My father, who was always afraid my mother would unplug him, refused to have a living will. And I said, well, Dad, would you trust me to make that decision? He said, I don't trust anybody. I don't trust anybody to decide when I'm going to live or die except for God. That was his comment. My mother, who would be appalled that she might be seen in a disadvantaged state, said, you better unplug me. You better unplug me early. So I, in my own family, have grown a full appreciation for that 180 degrees difference in how people view a living will. What's important is that you consider it. What's important is that you talk about it with your caregiver. That's usually your spouse, a child, somebody who's going to be really the person, whoever has your durable power of attorney for healthcare decisions, for sure, you want to discuss this with them. A living will is a critical instrument that you can file with your doctor, you can file with the hospital, you can carry one with you, and it will be recognized anywhere within the United States of America. It will be presented as evidence in other parts of the world, but it may or may not be conclusive. Typically in Europe, it will be honored after it goes through a certain process, depending on which country you're in. But definitely within the United States, it is honored and recognized. You include the do not resuscitate directions, but it's separate from all the other directions. One thing that we threw in here was the physician order for life-sustaining treatment, POLST for short. This is not something attorneys draft. This is something your doctor drafts. And this is an instrument that you can talk to your doctor about if you have a chronic illness. It gives permission, for example, for those around you to not have any liability if, for example, they do not call an ambulance when you're having a seizure. Some individuals have chronic symptoms that are frightening to other people around them. They want to have this order that says, please, don't take me to the hospital, don't run up a bill for me. If I die, I die, but I've discussed this with my physician. I know the limitations of what can and cannot be done for me, and through this collective process, it's determined that I do not have to be put through the additional inconvenience and expense and counterproductive time of going through these things that everybody else might think is necessary. So if you have any type of a chronic health ailment that either results in a lot of pain, results in seizures, there are some ailments where it appears that you stop breathing, those types of things, if people around you are scared enough, they're still going to call. But if you've made it clear that you have one of these, they can at least show it and there can be a decision that's made. And finally, the durable power of attorney for asset management. This is one of those big powers. And I always tell people, do not sign one of these unless you are signing it over to somebody that you trust implicitly and who is competent. And every family is full of folks that are trustworthy, but maybe not competent. And every family is full of folks who are competent, but maybe not trustworthy. So you have to be really clear-headed on making this decision because you are cloning your legal self. They can buy, sell, trade, bid on, access your accounts. They can do anything with a general durable power of attorney for asset management. Under Kansas law, we have a very specific list of powers that somebody, we call it a POA, somebody with a general durable power of attorney, a POA, has. Then there's a whole other list of powers, including the power to nominate a successor POA. That can be very helpful with elderly couples, where you have one who's the caretaker, one who's likely to end up in the nursing home, and then the caretaker finally gets a little bit older also, starts declining. They really want and need to nominate somebody to take care of their spouse that they've been taking care of for a number of years. So having that power is something that's a wonderful tool in the right situation. But you have to have those powers set out in your power of attorney, and you have to have elected them. You also can nominate that person to be able to sell your homestead. Remember, we talked about homestead rights. In Kansas, with real estate, if you're married, you can buy with just your signature, but you cannot sell with just your signature because of the spousal rights that we have in real estate, homesteading and/or marital rights. And so with a power of attorney that claims this particular power and includes a legal description of the real estate, then that person with the POA can, in fact, even consent to giving away your marital or homestead rights. And that's, again, a very helpful tool in the right situation. So the other thing to understand about all powers of attorney, they expire when the person does. Remember I said you're my legal clone? Well, once I'm dead, I can't act on my own behalf anymore, and neither can my POA. There are a couple of things they're allowed to do, including getting the will out of the safe deposit box that having that power of attorney lets them do. But that's about the extent of it. When that person is deceased, so are you. And you can be accused of fraud if you use a power of attorney knowing that the principal is deceased. And that comes up from time to time. So those are kind of the basics that I'm going to turn it over to Rebecca so that she can talk to you about transferring your assets and also about trusts.
Thank you, Kathleen. So Kathleen's done, I think, a very thorough job in a short amount of time of telling us how to make sure that our wishes are upheld after we're no longer here to make them clear. So I'll just put a plug in to actually going to visit an attorney to have that done. There's lots of specific language that needs to be done. They need to be proven in such a way, witnessed and all that. And you want to make sure that they really do represent your last wishes. So I know there's a lot of forms out there on, LegalZoom and Office Max and all that. I don't want you to be, penny wise and pound foolish on this, but take the time, take the effort, and take a little money and make sure it's done correctly. But we're going to talk about now avoiding probate. A lot of people want to do that. They want to avoid the cost. They want to make sure their assets are transferred as quickly as possible, and that can be done. There are certain caveats that we're going to talk about, though, so make sure I'm going to do this right. All right. First one, of course, is the big one. It's a trust. Trusts are not just for the ultra wealthy. Lots of people use them. We work with them every day in the trust department, the bank that I'm at. Usually you'll see reference to two different types of trust. One's called an inter vivos, meaning during life, or a living trust. And then there's the testamentary trust. Testamentary means, of course, with your will. So when you're talking to Kathleen and you draft your will, you can put a trust in there that will go into effect after your death. So we'll talk about it can have the same provisions that your living trust does. The requirements and parties for any trust. Requirements are that the person who's setting it up has capacity. They know what they're doing at the time they sign the documents. That they have the intent. That the trust is actually funded with assets. And then there's some beneficiaries named. The asset thing, I have seen firsthand problems with that. My very first trust job was with a bank here in town. It used to be called Highland Park Bank and Trust. And we had a customer come in, and I was speaking to him, and he says, well, I've got a trust. And he showed me this beautiful document that I don't know how much he paid to have drafted. And so I was asking him about, well, transferring the assets to the attorney, or, how'd that go? And he looked at me with the deer in the headlights look. And so basically the trust was unfunded. So unless you put your assets into your trust, and that means by changing the title on those types of assets that have title, and that can be real estate, your car, your securities, your bank account, your investments, all that type of thing, then it's worthless. It's not going to do what you want to have done with your assets, all right? So make sure and any estate planning attorney worth their salt will guide you through that and give you the exact language on how it needs to be titled, and tell you who to see and how to get that done. All right. The other thing, it has to be for a lawful purpose. You can't do a trust for something nefarious. The parties to a trust there's three parties. They can all be one person, and a lot of times they are. First party is the grantor. Sometimes it's also called the settlor or the trustor. And that's you. You're the person who's drafting having the document made. You're saying, I'm the grantor, I'm putting all of my assets into the trust, and this is what I want to have done with them. All right. So I'm setting up my trust, and I put my house and my car and my vast amounts of securities in there, which I don't have. I wish. And in there. And then I have to have a trustee. And the trustee is the person or the or a bank with trust powers, or a trust company. It can be either. And they're the entity or person who has the duty of loyalty and duty of care to watch over those assets and treat them as a fiduciary. They've got a very high level that they have to live up to in taking care of those assets and following your wishes. So again, as Kathleen was saying, make sure it's someone you trust, who's trustworthy and competent to step into that position. You can be your own trustee, and most people are. All right, so I'm putting them in. I'm trustee. My document says during my lifetime, trustee, if it's me or if it's somebody else, is supposed to give me all the income that I need, and and use up all the principal, spend down all the assets if they need to, so that I can maintain a certain standard of living or whatever. All right. So you know how you want to spend your money and take care of your assets. You're probably the best person to do that. When you become incompetent or upon your death, though, you've named a successor trustee or trustees to step in immediately and take over that job. All right. And then the third party is the beneficiary, and as the name implies, it's the person who benefits from the trust. During your lifetime, that's you. All right. If you have what we call a self-settled trust that we've talked about, where you're the grantor, you're the trustee, you're the beneficiary, the federal government and the state government won't recognize the trust for tax purposes. You go ahead and file your regular federal and state income tax returns, you use your own Social Security number because it's really, for all intents and purposes, it's your own stuff. Once a new person steps into the game, be it a new beneficiary or a new trustee, then we have a separate entity created. And at that point, trustee needs to get a tax ID number, file trust tax returns. It's a 1041 and a K41, and go forward that way. All right. I am going to just put a plug in here for corporate trustees since I work for a bank in the trust department. The big benefit I see of naming an uninterested third party to be your trustee is to avoid family issues. I've seen it over and over and over again. For example, a family with 3 children, 2 of whom are very, down to earth, got their head on straight, very frugal with their finances and take care of things. Then there's the third one who's kind of a spendthrift or has had trouble with the law or something like that. So mom and dad say, well, we're going to name son number 1 as our trustee when we're no longer living. Our trust says child 1 and child 2, who are the golden children, they get their third outright. But, we're going to have son number 1 keep that last little chunk in trust for the benefit of loser kid. And so you can see right there that Thanksgiving dinner and Christmas aren't going to be real happy when child number 3 just can't understand why his older brother or sister has to have the purse strings, and there's a lot of tension involved there. If you have a corporate trustee with a trust officer such as myself, we can be the bad guys, and we can, run interference among the family members and just take that tension off the table and promote family harmony. So there's my plug for trust companies or banks to do that. Okay. Reasons to choose a trust, lots. We talked about the voiding probate situation. When we're seeing more and more with the Medicaid laws and as Kathleen touched on too, is if you have maybe a child or a family member who has special needs. And that trust then can be written in such a way, and it's very particular in the way it has to be written, to provide assets to that child or beneficiary in such a way that they're taken care of, but they can also still receive Medicaid. And Medicaid will pay their basic expenses, but this trust money can be set aside, and the trustee can use that money for things like Medicaid or other government types of programs won't pay for. And they don't have to spend down those assets. They can use them. So, we're trustee of several of these trusts. Depending on the assets and the lifestyle, we've paid this one gal's vet bills for her sickly cat because she doesn't have any money to do that. And it allows her, some joy in her life. And, we give her some money every month just so she can go to movies with her friends and, go out for a coffee and that sort of thing. So it can be used to take trips and bring someone along with them. But if that money were to be given to them outright, the government's going to say you have to spend it all on your own care first before we're going to be able to give you Medicaid benefits. So that's a special thing to do. All right, I'm going to move on from trusts and talk about transfer in death and payable on death. These are 2 terms that we use, and you're probably familiar with them, to put onto different account designations. So say you've got a checking account and a savings account, a couple of CDs at the bank, and you want your kids to have that money after you die, but you don't want them to have access to it now. So great. You go in, you fill out the paperwork, you say, Joe and Jill each get 50% of these accounts. That's great. And like I say, they can't walk into the bank until they have a death certificate in hand and say, okay, pay us mom's money. Transfer on death is the same thing, but it's used on other types of assets like your real estate, your securities, stock bonds, brokerages, investment accounts, that sort of thing. What happens, though, the drawback on this, and we saw this happen in our bank here about a year and a half ago, if your beneficiary dies before you do. We had a gentleman who, a customer in another branch, who had a CD and filled out all the paperwork. He had 3 children. He named, a little bit of time, named 1/3 to go to child 1, 1/3 to go to child 2, and the other third to go into trust for child 3 because, again, it was a disabled situation. That's wonderful. Everybody knew what was supposed to happen. Well, less than a week before Dad, the owner of the CD, passed away, one of the sons passed away. So everybody who knew Dad knew, well, his intent would be that son 1's share would go to his children. And that's what most people would have assumed. But you have to look at what the document says. And yes, it was a form, but it was signed. And the form said, if one of the beneficiary predeceases, his share goes to the other beneficiaries named. So, and we were named as trustee of the daughter's trust. So we had to insist that daughter's trust not only got her share, but half of her brother's share. The other brother, if he wanted to, he could disclaim and say, you know what, no, my half of brother's share is going to go to his kids. But, as a fiduciary for a daughter's trust, we could not do that. So they're great tools, but you have to be aware if situations change, get in there and get those updated as quickly as you can. Okay. Joint ownership, Kathleen talked about this a little bit, and you're probably all familiar with it. Joint tenants with rights of survivorship and tenants in common. JTWROS is really the one that's most used most of the time. And that, you see it a lot with husbands and wives, and that just means we both own the property, an undivided half of the whole or undivided share, and first to die, the other party, the other joint owner gets 100% immediately. Tenants in common is a little bit different. They both are on there as owners at this point. First person dies, his or her share goes to her heirs. All right. So a lot of times you might have to force a sale to sell the house or real estate or whatever it's called. We'll see a lot of times little old ladies come in and say, well, I just want to put my kids on my accounts as joint tenants with right of survivorship. And that's totally fine if that's what you want to do. Be aware, though, the presumption under the law is that child is a part owner of that actual property, even if he didn't put a dime toward it. If that son gets in trouble with the law, has a bankruptcy, a divorce, a judgment against him, that asset could be attached, and it might be. Now, you can go in and prove or try to prove that, you know what, all that asset really is the fruits of mom's labor, but that's kind of a burden to have to bear. So I think in situations like that, it might be better to look at the transfer on death or payable on death, because upon mom's death, then son will get it. But he or his creditors, neither he nor his creditors have claim to it until that point. Okay. Beneficiary designations. If you have an IRA, if you have life insurance policies, if you have any kind of retirement plans through your work, please make sure your beneficiaries are up to date on that. Usually we name a primary beneficiary or beneficiaries and a contingent or secondary. With most retirement plans that are covered by ERISA, you need to name your spouse as your primary beneficiary. And now, there may be situations where you don't want to do that. And it's not because you have another boyfriend on the side, but it may be because you have children from a prior marriage and you've already got things worked out where my stuff goes to my kids, your stuff goes to your kids. So you can name your children as your primary beneficiary, but husband or spouse has to sign off on saying, I understand that that's what's going on, okay? And naming children as a beneficiary can run into problems here too with them being minors. If something were to happen to you before they're adults, and you can name trusts as beneficiaries of these. There's a lot of special hoops you have to jump through to make sure that things are handled the way you want them to do. So again, that's worth talking to your attorney or your trust officer or banker to make sure that that happens the way you want. Same thing with life insurance. Make sure your beneficiaries are up to date. Anytime you have a change in a situation in your life, death, divorce, new children, whatever, please make sure you're going to be changing and updating your beneficiary designations. Once a year when you change put your clocks back and check your fire, your smoke alarm, check your beneficiary designations while you're at it. Okay. And as Kathleen also talked about, let's not forget digital assets. This is all kinds of things are going on there. You may have these as part of a business you're running, so online businesses, your PayPal account, if you have money in there, and not only monetary assets, but think about your Facebook page or your LinkedIn or your phone. I mean, there's just all kinds of stuff out there. Your digital afterlife, your email accounts. I guess I feel like that person that you trust and is competent, he or she has access to your little cheat sheet with all your passwords and your usernames and is under strict orders to go in and shut that stuff down as soon as possible, or put the memorial on your Facebook page and call it good. But don't forget that those things are out there and need to be taken care of at this point. So, all right, definitions, we talked about that. Look on your list there on pages 145 and 46. And now it's time for cake. Congratulations on completing Women and Money. I know they're serving cake, so maybe get a piece of cake, come back, and we'll do Q&A. We'll bring it around. Oh, okay. All right. So let's go ahead and can we come back to you then? Yeah. Okay. Yes, ma'am.
So I'm very young. I'm not married. I'm having children. What happens to my stuff if I just die? I mean, 'cause I don't have a will or anything. I don't have much stuff. The most expensive thing I have is my car. So, can you repeat the question?
Yes, I'll be glad. The question was, this is a very young questioner, and she says she doesn't have very many assets, and she's not married, and what does she need to do? What happens to you? What happens when you die? Your assets, whatever they are subject to intestate succession. So if you're not married and you have no children in or out of wedlock, then it goes back up to your parents. If your parents are deceased or divorced, one half goes to one parent, one half goes to the other. So mostly the concerns you would have, though, and this is a very typical situation for young adults, often talk to families with college students, you really need at least a limited durable power of attorney, for example, so that your parents can access your bank account. You may only have $50 in there, but it is $50. You may only have $100. You may have an account at the college that is for books or tuition or for food or something else. So some type of tools are very, very helpful. You still want a living will. At your age, you can be in a horrible car accident. Your parents need to have that authority. If you are 18 or over, you're an adult. You have to indicate what your decisions are and what your preferences are in these situations. One of the other things that I did not mention on wills, if you don't have a penny to your name but you have minor children, the greatest thing you can do is put together your will and designate who the guardian should be in the event of your death. Likewise, if you're a young person, you don't have very many assets, you don't have to worry about asset distribution, but there are a lot of events around your death that you need another adult who's able to come in and have authority to act on your behalf. Okay, are there more questions? Yes?
Remember mine. Rather than a trust, if you're doing a will, and I'm old, I want to do a will, but can the lawyer, if you hire a lawyer, can he be the executor? Because I sure don't want any of my kids.
And the question was, if you don't have anybody else, can you choose an attorney to be your executor? And yes, you can. Yes, ma'am.
On the transfer on debt, I've had to pay on that, I understand that works. But if I have real estate and I want it to go to my fiance, not my grown children, is that better under the will or is that better under the transfer on debt?
You can do it either way. Transfer on death would be a lot quicker. I mean, it just make. You would need to record a deed that shows that on there. Yes, it needs to be recorded at the courthouse.
And you can Google transfer on death deed, and you'll get a number of different forms that typically have the language. One of the other things I'm going to mention that Rebecca spoke to in terms of online resources, there really are a lot of great online resources. I always say the reason you want to go to a professional, because I use templates also, and so if you compared my forms with an online form, you go, well, it's the same in this, and this, because they're standard language that's been construed for a long period of time. My value is that I explain to you what you're doing and whether or not it actually does what you want it to do. Your challenge when you go out, if you don't know enough about the law and how it works, and the specifics of probate law in particular, you may think you have done what you need to accomplish what you want, but you could be very, very wrong. And so I encourage people, I'm not trying to take more money. I try and do flat fees. I think most good attorneys do. They try and work with their clients because we want you to have the tools that you need. If you have questions, since you're at this seminar, you do have access to giving me a call, even though you're not a client. I will try and at least answer general questions. And Rebecca, I know, feels the same way. Okay?
Would it be a good idea to fill out one of those blanks and take it with you to the lawyer so you have some of the stuff covered and you know what he's going to talk to you about?
I think it's a real helpful tool to have the information that you need. If you bring one of those blanks in to me, I'm not going to sign off on anything that I haven't prepared, but you're talking about I do an intake form that says this is the information that you need to bring in and these are the questions you need to think about. And a lot of times, even when they have those intake forms, clients are like, okay, I need more input to even think about it. And so that's the other thing an attorney should be able to do for you too. Okay, any other questions? Yes, ma'am.
With the will, you said a power of attorney ends at death. The will then can actually grant you into the will that you're going to sell the home they're living in, and then the proceeds would go to the beneficiaries.
A will says what you want. The question was, if you have a power of attorney that ends at death, can you write into the will what you want to have happen, for example, to a piece of real estate, and that you want it sold at your death? And typically what an executor's job is to gather all the assets and to make a decision. They're going to sell that asset. What you want to write into the will, if you feel strongly about it, is that if you want your family members to have the first opportunity to buy it, and if you want to authorize that they buy it at a discounted amount, that's what you would need to write into the will. Selling the property is going to be something that the court will either look to supervise having done or the executor will do. If you want anything else other than sold and split among your beneficiaries, that's the kind of thing you need to cover in your will.
So, no, I don't understand. When if you have a will and you appoint someone to sell the property after your death, you still need a court to decide that?
It depends on who owns. The question is, if you have appointed somebody to sell the property on your death and you have a will, do you still need the court to be involved? And I think perhaps we need to clarify what exactly you're thinking by appointing somebody. The question you have to answer is whether or not the person you've appointed has power after your death. If it's by a power of attorney, they do not, so they cannot sell it after your death. If it's by virtue of one of these transfer on death deeds, then it will happen by operation of law, and you never have to go to court about it, period. The title goes to who you want it to. When they get title, they can decide if they want to sell it or not. And then finally, if you have placed your real estate in a trust, then the trustee can make those decisions. So if you've appointed a trustee through a trust document, then the trustee can make a decision to sell that house at your death. If you have not done any of those things, then especially with real estate, it has to be probated in order to pass good title. And I'm sure you've heard of situations where somebody's been living in the house, nobody ever bothered to go to court and say, well, Dad died, 10 years ago. Mom kept living in the house, but she never actually had title to the house for whatever combination of reasons. So when Mom died, we tried to go and sell it to third parties, and lo and behold, we didn't have good title. So then you go through a proceeding called a determination of descent to say who has actual title to the house. So you have to make sure the person has authority, that the authority lasts beyond your death, and depending on how you have titled it, then that will tell you which person has the authority to take that action. Okay?
You can't just make an executor or executive trust. I take care of my husband on land, and his daughter lives in Utah. And so, and neither one have much money. But if something were to happen to him, he's asked me, would I sell his home and make sure his daughter got the money for that? Do we have to set up a trust to do that?
You can set up a trust. He at least has to have a will, or he has to transfer title to you.
No, that's what I'm asking. Oh, can he do it with a will?
He can, but then you have to probate. So it sounds like he really truly does need to talk to an attorney about what he wants to have done and the options and make a decision. The way it stands right now, he can't simply say, "Will you do that when I die?" You won't have authority to do that unless you go to court and get authority.
Even in a will, the will doesn't.
You present the will to the court and ask the court to appoint you as the executor or executrix. Until the court appoints you, you have no power.
I'm wondering, in a situation with the gentleman, is Jayhawk Area Agency on Aging, would
Yes.
that be a good place to
Yes.
go for low-income elderly people? They might
Yes.
be, I'm not sure if they have attorneys on staff or legal aid or something. It might be a little more cost-effective for someone in that situation.
Is his daughter the only heir that he has?
Yes.
Then he may simply want to execute a transfer on death deed.
That would be cheapest, yeah.
Okay?
She lives in another state, that means she'd have to come here to sell it, correct, I guess.
So long as she has good title, then she can appoint you and nominate you as an agent locally to represent her interests. Okay? Somebody who has good title then has the power to appoint, with a limited durable power of attorney, another individual to act on their behalf. Okay? There are other questions? Yes, ma'am.
Just a quick question. We've talked about transferring assets, but what do you need to do to plan for debts that you might have? Whether they're student loans or, home mortgage or all of these different kinds of things. Are there, it's just, how does that happen?
And repeat the question.
I think the question is, we've talked about transferring assets, but what happens to your debt upon your death? If there's a mortgage, of course, the lender is going to have right to foreclose on that house or force the sale to get the rest of the money back. I don't know what happens to student loans. Do they just... I mean, they'd have a claim against the estate. Part of filing your will and probate means to prove is that you give a notice to creditors. The executor gives this notice to creditors, and they have a certain amount of time to file a claim against your estate. And if they don't do that within, what is it?
4 months.
4 months. See, she does this all the time. Then their claim goes away. So, if there's not enough assets to pay all your bills, and there's a certain order in which they can be, in which they're paid, then too bad, so sad, I guess.
And I will tell you honestly that anybody who has a spouse or a family member who dies who has left quite a bit of debt as well, go to an attorney. Don't pay one dime or $1 on anything until you've gone and gotten legal advice. Depending on how the assets are titled, that creditor may or may not be able to reach any of them. Credit card companies are among the most notorious, where dad, a husband has a card in his own name. The assets are joint tenant right of survivor, so the minute he dies, that goes to wife. There are no assets left for dad, and yet the credit card company will dun wife for, the husband's debt, and she is not obligated to pay that. Now, if they've discussed it and they have assets and are able to do that, that's a personal decision between them. Or if it's a joint account, right? But those are very important questions to figure out. One of the other processes that you need to be aware of, if you have debt and you do have assets, creditors are authorized under the laws of the state of Kansas to file to probate an estate for themselves. They don't have to wait for you to send a claim. They can go and file and say, we want to probate the estate of John Doe, deceased, and we are going to go out and look for every asset that John Doe owns because we want to satisfy our own claim. And so that's another option. Not a lot of creditors do that, quite frankly, but some of them do. And so if you are handling an estate or you're in a situation where someone near and dear to you has died and there is debt, go spend a few $100s with an attorney and figure out what your options are. And typically it'll save you quite a bit of time and frustration and quite a bit of anxiety and worry. Because where you know who the debtors are, we send out a letter when we file the petition to those known debtors and say, hello, debtor, we filed an estate. You now have 30 days to file your claim, or you're out of luck. And so those are some of the other strategies you use. You don't hide from debtors, or from creditors, rather. You go ahead and put them on notice. Now the ball's in their court to act in a timely manner. And especially where you have out-of-state companies, if they're not active in the state of Kansas, they may or may not know that. So there's a lot of strategies that can be used to minimize the impact of surviving debt on the decedent's estate. Are there any other questions? Yes, ma'am.
When you say that the spouse has to sign off if they're not the beneficiary, does that count for common law marriages?
I would say so.
It does.
I don't think Kansas, didn't they do away with common law a few years ago?
We have for many, many decades. And when I was talking to you about the impact of non-conventional, non-traditional relationships, this is one of those other impacts in terms of trying to avoid somebody coming in and claiming that they have a common law marriage, even though Kansas doesn't have a same-sex marriage statute. And so there's been some preemptive decisions in certain areas. And I'm not saying that's the only reason. But I'm saying when I tell you that there's a lot of impact on how things actually work, there really is in surprising ways, both good and bad. Yes, ma'am.
So a couple that chooses to live together but not married, is there still some, if they own property together or in a committed relationship, that can say whether it's same sex or not, does Kansas have, if they don't recognize common law marriage anymore, is there still something that recognizes their
The relationship becomes irrelevant. At that point, you're simply looking at the titling provision. So if myself and my neighbor both saw, this would be a tremendous investment, we ought to buy this vacant lot between our houses so we can control who buys, etc. We're not in a long-term committed relationship, but the property is titled. We make a decision whether it's tenants in common, meaning we each own an undivided 1/2 interest, or if it's joint tenant right of survivor. But looking at titling issues, that always comes first. The reason marriages impact titling issues is because there's separate statutes for married couples that create homestead rights and marital rights. So those separate statutes, it's a creature of the statutes. If the statutes weren't there, it would also be irrelevant. There's no inherent right as a married couple to have the other person's property, except for the statutes that create that right. And the reason they did that, when you look, it's a very fascinating subject actually to research, because public policy is in favor of families, and it's in favor of taking care of obligations. And families where there are members who are not taken care of soon become individuals who need the help of the other persons of that state or that country. And so for taxes, et cetera. So there's a public policy reason for supporting that you don't abandon a spouse without their consent. Okay, any other questions? Yes, ma'am.
I'm in the neighborhood where I was a caregiver, doing power of attorney for my elderly uncle. My uncle passed first, and then she had a will. My aunt passed second, probably 6 to 7 months later. The will was never filed by my aunt. I only found the will after she passed. And they were telling me there's no need to file it at that time because the time it lasts over 6 months or 8 months.
6. Mm-hmm.
It still leaves me doing all the finishing up all the details and not have access. So I'm starting to work with probate. But what can we do with the second will? Because in his will, everything is spelled out how it should go. Is it too late to try to turn, get that into probate or?
There's a 6-month drop dead deadline, no pun intended, or maybe. You must file a will within 6 months of date of death, or it is as though a will was never written. If you know where a will is and you fail to do it, and you're supposed to be a beneficiary as an heir at law, other beneficiaries who would have benefited from that will and you didn't do it, you are penalized for that by the probate court when they make a determination. So if it's within 6 months of date of death of either your aunt or your uncle, go now and record that will, whether or not you open a probate estate. You can decide when you work with an attorney if you can do it in a determination of descent proceeding. Because what we look at is what are the outcomes? What are your choices? What are the outcomes? What's the most efficient path to getting these assets transferred to where they were supposed to go? If we can do that without the will, we do it. But if the will made provisions that would be different than the intestate provisions or determination of descent provisions, then we want to have that as an option. Okay? How are we doing on time? Do we have time for one more question? We're doing good? Okay. Yes, ma'am. It's called a will affidavit, and it is the $79 is the filing fee that you pay to the district court clerk. And it just says, I have this original will. I may or may not ever open an estate with it, but I want to have access to it if I ever open an estate with it, and I am affirming or swearing that this is the original will that I have, that I verified that it is, and I'm going to file and record it for posterity. I may never touch it again, or I may need it. So you pay your $79 filing fee, you complete the affidavit that's signed by a notary public, and you record the will with the court. Okay? Any other questions? Yes, ma'am.
On a living will, was there any time frame to be renewed? My mom went about 15 years ago, did a major surgery, she's facing something now. Is that still a valid document, or should she redo it?
It should still be a valid document. If any of her directions have changed, it's like anything else. You want to take a look at what you've done. Over a period of time, you may have nominated somebody that you would nominate somebody differently. You may understand more about a process than you understood before and have a strong feeling about it that you didn't have before. So just review it and see if it still matches her wishes. If it still matches her wishes, then you're good to go. Okay? Any other questions? Well, you guys have been wonderful, and I think Rebecca and I have both mentioned if you have questions, feel free to let these folks know or to get hold of us, and we will be delighted to either try and accommodate your question and get you some information or refer you to somebody who can. And as a closing comment, I too am going to affirm that if you have estates that are over $150,000 in a trust, I really always strongly encourage consideration of corporate or institutional trustees. For two reasons, not just for the reasons that Rebecca outlined, but also because they have investment opportunities and investment expertise that most people do not have. And so you can be assured of more consistent returns and that type of thing. You do have to check and see what their minimum requirement is. Some institutions you have to have about $250,000 to $300,000 to make it to justify the rates that they charge. So just check ahead of time, but consider that if you have a long-term situation. Thank you guys very much.
Thank you.